Donald Trump's lawyers have filed their long-promised motion to dismiss the federal indictment on election-related charges, arguing that Trump has absolute immunity from criminal prosecution for his actions. The document is full of bluster that masquerades as legal argument. This wouldn't lead to case being dismissed, but it might just have the intended effect of delaying trial beyond its scheduled March 2024 start. Trump's audacious argument, supported by cherry-picked quotes and misleading quotations, is that he cannot be prosecuted for any of his actions as long they are within the outside sphere of presidential power. In a motion filed Thursday, his lawyers argue this absolute immunity is necessary to ensure that the president can serve without hesitation, without fear his political opponents may one day prosecute him for decisions they do not like. In fact, they argue that Trump's actions to ensure election integrity were not just within this external framework but were central to his official responsibilities as president. This claim is unconvincing, and that's putting it charitably. For example, the Justice Department has long argued that sitting presidents cannot be prosecuted for their actions. But this view, assuming it is correct, presupposes that indictment and prosecution are possible after a president leaves office. Follow Ruth Marcus insights otherwise. What was special counsel Robert S. Mueller III doing to investigate Trump's official conduct and conclude that there were 10 possible cases of obstruction of justice? This problematic behavior was, in the words of Trump's lawyers, far more central official responsibilities than his frantic efforts to pressure state officials and own vice president help him overturn the election results. In Trumpworld, a current or former president can never be held accountable for his actions. During Trump's second impeachment trial, a different group of Trump lawyers insisted that the Senate lacked the authority to act because Trump was no longer in office. Republican senators, including Minority Leader Mitch McConnell, have argued that Trump should not be convicted for that very reason. We have a criminal justice system in this country. We have civil litigation, McConnell said, and former presidents are not exempt from being held accountable for both. Without even bothering to try to explain the discrepancy, criminal lawyers insist that impeachment and conviction by the Senate provides a special method for bringing charges against a president for crimes committed while in office. And not only Trump has nerve to claim his acquittal, which he won in part on argument Senate lacks authority to try him, means criminal prosecution is now barred. The Constitution provides that an unconvicted president cannot be subject to criminal prosecution, as it states that only a convicted party can be liable and subject to indictment, trial, judgment, and punish.